All right, next case on the docket is MAZZARESE versus Southeastern Freight Lines. May proceed. For appellant, may proceed.
Good morning.
Good morning.
May it please the court. My name is Steve Haskins, and I represent the appellant in this matter, Paul MAZZARESE. And I'd like to take this opportunity to reserve 5 minutes, if I may, please, for my rebuttal. Appellant believes that the attorney's fee award in this case in favor of the defendants was based on an invalid proposal for settlement.
Before you go on, can I ask you real quick?
Yes, ma'am.
Do you dispute the entitlement to the taxing of costs pursuant to 5704?
I do not. They were clearly the prevailing party.
Okay, all right.
Right. For two reasons. One, it was an invalid joint proposal that didn't differentiate the amounts.
Was that argument made below?
I'm sorry, Your Honor?
Was that argument made below?
I brought to the attention of the court the case that the Andrews Fry case that Your Honor authored.
And you basically said to the trial court that that this case appears to be dispositive, correct?
I did say it looks like this might be.
Okay. So we've got it.
However,
we got a situation vicarious liability was not in dispute.
Correct.
Same as in Andrews.
Correct. But what is different, Your Honor, was in the Andrews case, the sole offeror was the active.
What difference does that make?
Because I believe it makes a difference because I think, in my mind, there is an independent claim against the active tortfeasor in this case. Remember, in this case, the sole offeror was a vicariously liable party.
Okay. So what?
Judge, I could have just said, I'm not going to proceed against this vicarious liable party. I'll just bring in this active tortfeasor.
You want to go against the empty pocket rather than the deep pocket. I understand. That would make sense.
That was not a concern here because he was covered, okay? He was covered, Your
It's
Honor.
covered under the employer's insurance policy.
Right, but it didn't take bringing that into the,
But this case is, but in the Toll Brothers case, in that particular case, the vicariously liable defendant is the one that issued the offer of judgment, and so it's very, very much like that case. And
it is, Your Honor, except they didn't really give much of reasoning in that case. That district court of appeal
Did you specifically make that argument to the trial court? Did you say, Judge, this is, Andrews is distinguishable because it involved the active tortfeasor, not the vicariously liable tortfeasor. Did you make that argument to the trial court?
No, what I believe I said was, Judge, here's this case out here by the 5th District Court of Appeal. Back then, I was under the impression that this court had had a problem with that and had certified the question up to the Supreme Court. That is this an invalid joint proposal?
All right, so the answer to the question is no, you didn't make that argument below.
I didn't sit here and no, I did not say, here's the difference. But I said,
You're a court of correction of error. If you don't make an argument below, you can't bring it to us and say, well, the trial judge erred, reverse the trial judge. It's not a preserved issue. And it seems to me that you did not make this argument below.
No, Judge, what I did say is I believe that this is properly or should be before the Supreme Court because of the phrase questioned by this court in that I felt it was the same thing. It was.
That's not preserving the issue.
Well, I think what I was doing, Judge, was just doing my duty to inform the trial judge of some perhaps adverse ruling that...
And then if you have some basis to distinguish the case, then that's what you do, but you didn't do that. There wasn't this effort made, like you're doing today, to distinguish the case by saying, well, wait a minute, Andrews involved the active tortfeasor, our case involved the vicariously liable tortfeasor. That argument was not made and could have been made below.
I felt that I'd done what I could, Judge.
Let's assume that for the sake of discussion that we don't believe that you preserved that issue. Where do you go from there?
Well, the second basis is the release issue, which I did certainly talk about there.
Now, did the offer of judgment require the release to be signed?
No, there was no mention of a release in the offer of judgment.
It had the release, and you go to the flip side of that now. Had the release, or had the offer of judgment said something along the lines of, in execution of the release, attached here too, would that have been adequate? Or did in your mind and your argument, does the offer of judgment have to set out phrase for phrase the terms of the release, even though the release was in...
I don't believe case law makes it necessary that it be a complete recitation of the terms of the release. However, the offer of judgment here didn't say anything about the release. The only condition in it was...
Voluntary dismissal.
Correct.
Okay.
With prejudice. And
so was there anything that prevented you from accepting the offer and ignoring the release?
well, here's the problem that poses. When you get an envelope to you, Judge, with a pleading, such in this case, the offer of judgment and the notice of serving of that offer of judgment, and there's also a release there, the receiving party shouldn't have to think about it. They shouldn't have to call up opposing counsel or write opposing counsel a letter and say...
Just ignore it, which is what you did. Just ignore it. Just ignore the whole thing. Ignore the offer of judgment, ignore the release, ignore it all. Go to trial, you lose, then raise these issues.
No, not at all, Judge, because when I got the offer of judgment...
Did you respond to it?
No, I did not.
Okay.
But when I got that offer of judgment back then, Judge, this court, we were in the 5th District Court of Appeal, I was assuming they were going to pretty much follow the law in the Lamb case and in that DAB Constructors case, which pretty much my reading of those cases was, hey, this offer of judgment has to set out the amounts attributable to each of these parties. So I'm working under the Lamb case.
Fair enough.
Okay.
Was the release stapled to the judgment, or was it attached to the offer of judgment, or was it just it seemed to me when I was reading the briefs that I couldn't tell whether it was in the envelope or whether it was actually attached to, stapled to it, like this is part of the offer of judgment.
Your Honor, I can't honestly answer that question. Okay. I do not know. I do know they came together in...
Well, I don't think that's in dispute. It was just, I think that...
No, I couldn't tell if they were stapled together or not, so... But, yeah, I don't think it's incumbent upon the party receiving it to have to call and say, hey, what's with this release? Hey, you sent a release here. I believe the case law requires these offers of judgment to be pretty much self-executing. You get them, you review them, you weigh them, you do all the things, thinking them through, and either accept it or reject it.
Let me ask you this, what is the release is there, what ambiguity did the release create?
I'm not so sure the release created the ambiguity as much as the having two documents together.
But they're not
where-
inconsistent. I think that this is Judge Berger raises a good point, which is the concept here is that there has to be something that impacts your ability to analyze whether you should accept the offer or not. What was it? What difficulty did that raise that affected your ability or impacted your ability to value the case? And you got it wrong.
Well, for the one reason, when I read the offer of judgment, I didn't think it was a valid judgment.
Well, all right,
Okay.
but we're-
Other than that, well, the release, I mean, here's the offer that's pretty clear on its face. All you need is dismissal.
But the release didn't impact your ability to decide whether you're going to accept this or not.
I'm not so sure of that, Judge. The release was, yes, pretty much standard fare throughout a lot of it, but the provisions pertaining to subrogation, indemnification, and all those things were particularly onerous on...
It's a standard form release.
I don't know if I'd go that far, Judge. It was, a lot of times you see that in there, but...
What's unusual about that release?
Well, I just think it went overboard on having Mazzarese and his attorney basically representing this, and that this was going to be paid and that was going to be paid. Once again, I mean, it should have been, it caused a question. And I think that's what offers a judgment should not do. That is, you get it.
I'm trying to understand what that question was.
Why do we have these two documents here when one doesn't mention the other?
Okay. In a personal injury case, you have an offer of judgment and a release, and that's a shocking thing and surprising to you?
No, it's not shocking, but based on my understanding of the case law surrounding proposals for settlement, they required that if you're going to, number one, that a release, according to the State Farm Nichols case, is a condition, a non-monetary condition of acceptance that should be in that proposal for settlement.
Okay, so if it had said, see release attached here too, that would have been okay, but since it was simply in the envelope, that's not okay.
No, once again, Judge, it caused question and wasn't self-executing.
Well, was there anything that they could have done in terms of release that would have not caused a question in your mind?
Yeah, put it in the offer of judgment and make reference to it.
As opposed to having it right next to it. That would have, so if they had repeated it in the offer of judgment, that's no question for you. But if it's in the envelope, that is a question for you.
Now, Judge, it boils down to this, at least in my mind, that these offers of judgment, these proposals for settlement, have been consistently held by the courts to be strict construction of the rules and of the statute pertaining to those.
The purpose of the offer of judgment is to encourage the settlement of cases so that we're not going to having judges that are going to trial on cases that are just frivolous or should have been settled. That's the purpose of it, is to settle, get cases settled, right?
Yes, it is.
Okay. And so how do you factor that into the equation?
Well, this case was not going to, I'll be honest, this case was not going to be dismissed, and that offer wasn't going to be accepted for that monetary amount.
Apparently it should have been, in retrospect.
Well, yeah, I mean...
You'd rather roll the dice and let the jury decide rather than take the small amount, right?
No, that was my...
I would have thought that, but in any event.
I mean, this was a case of...
Do you see any way that you can distinguish this case from Nichols?
No, Nichols, my reading of Nichols is when there's a release, it has to be recited in the offer of judgment. If you're going to require a release, it's got to be recited as a condition of acceptance in the body of the offer of judgment.
If it was in fact in
accordingly.
this case a condition, I mean, if you read the release, if you read the offer of judgment, the release is not a condition, so you wouldn't have to sign the release. In Nichols, the release was a condition in the offer of judgment, and in that particular case, the release was ambiguous because it seemed to require the plaintiff in that particular case to give up some rights to another lawsuit in a different case that had pending, which created some sort of ambiguity there, which is why I ask you in this case, since the release, although it came in the same envelope, the release was not part of the offer of judgment. What in that release, and you've already said that you weren't going to accept the offer because of the amount. What in that release created some sort of ambiguity that would have made it difficult to understand or to be able to evaluate the offer of judgment? Because you just indicated that the offer of judgment was not going to be accepted because you weren't going to take $2,500, or your client wasn't going to take $2,500, because in reading back through the transcript, you mentioned at the hearing even that the litigation fees were already over $3,000.
Yeah. No, I'm not representing to the court that this release posed the type of problems the release in Nichols would have posed. That is, releasing things that had, in the future that had nothing to do with that particular lawsuit. There was nothing, and I'll represent to the court, there was nothing in that release that was, the terms of which were troublesome, okay? They pretty much were confined to that action and the claims that had been brought in that action. So there wasn't any ambiguity in the release, and I don't mean to suggest that. What I'm suggesting is when you get the offer of judgment should be clear. You shouldn't have to go through these thoughts in your mind. What's this about? Why is this here? What do I need to do? I don't think that's what these offers of judgments are for. You should get them, evaluate them, and accept them or reject them. Is my time up?
You've got a couple minutes left. A little over 2 minutes. Okay, you want to reserve it?
Please.
Okay.
May it please the court, Mark Tinker on behalf of Southeastern Freight Lines and Robert Koval. Just to start at the beginning, as far as the preservation...
Why send a release? Why send a release with the offer of judgment?
I can't tell you that. I can tell you for sure that there's nothing in the record that says if it was inadvertent, how it got in the envelope. We just know it was there. I also can tell you the question you asked, I don't think there's anything in the record that says if it was stapled or just happened to be there. So it's a question I can't answer. The important question, and I think that resolves the issue, is looking at what is the effect of it being there. And there's a couple things. First is, I think the law is well established that the proposal for settlement rule and statute need to be strictly construed. Counsel's own argument here today is that the law is well established that if you're going to require a release, you have to say so in the proposal itself. This proposal didn't say you have to sign the release. He could have very well accepted it, said, I want the $2,500. This says what I have to do to get that is dismissed with prejudice, and that's it. The second issue is, as Judge Cohen pointed out, I don't think there's any legal effect to the release being there. It's not requiring anything other than give up your rights to this lawsuit, which is exactly what the proposal saying dismiss with prejudice would do. The lawsuit would be over. The release doesn't do anything other than that, which I think is what
What's the difference if it, as Nichols says that if it's a non-monetary condition, you have to put it in the offer of judgment, and that wasn't done here, but you sent the release anyway. What's the difference between that situation and not clarifying in the offer of judgment whether there was a release, but whether it had to be signed as a condition of the offer of judgment.
The difference is
And
Nichols,
isn't this even a more egregious case? If it's not even, nowhere mentioned in the offer of judgment, but it's included when it's sent out, isn't that even more egregious?
absolutely not, and here's why.
Okay.
Nichols created an inconsistency between the two. The proposal said the claims we're attempting to resolve is this lawsuit, and you also have to sign this release, and then the release says the claims you're resolving are this lawsuit and that other lawsuit that you have. So they're two inconsistent documents. Here, whether the release is signed or not, there's only one claim and there's only one thing to give up. You do it by dismissal with
I know, but it
prejudice.
doesn't make any sense that you would send a release without explaining in the offer of judgment that, it's a non-monetary condition that needs to be signed in order to accept the offer.
Well, I don't believe
Just
it
sending
needs
it
to be signed.
and having them guess. What are they supposed to do? Just read it and say, well, is this a condition or not? Nichols says if it's a non-monetary condition, it has to be clearly stated in the offer of judgment. This is a release that came along with it. I don't know what to do with it. So what are they supposed to do?
I believe that they do what the proposal says. They can accept it by dismissing with prejudice. That's it. I believe that's the strict construction of the proposal and of Nichols says if you're going to require a release, you have to say so. They didn't say it required a release. Just said all you have to do is dismiss with prejudice.
If it's interpreted as a non-monetary condition that's not properly included in the offer of judgment, why do they have to respond to it at all if that makes the offer of judgment invalid?
Well, I don't believe it makes the offer of judgment invalid. All they have to do is read the offer itself and see what it says that they have to do, and all it says is they have to dismiss. I don't believe the inclusion of a release in the envelope or anything else that might have been in there. I mean, it could have been put together with other pleadings and a bunch of things served at once. Just because it's there, they evaluate the proposal based upon what the proposal says. It says that this is the one and only condition to dismiss.
Are you saying that there's an issue of fact as to whether the release was with the offer of judgment, or whether it came separately, or how that occurred, or?
No, I
whether it
don't
was-
believe, no, because I believe, again, that all you do is you look at the proposal itself. There are no facts to evaluate at that point. And, I think overall, one of the concession that was made here today is they weren't going to accept it.
Well, how do you say they got the release? How did they receive the release?
Based upon what's in the record, we know it was, and again, I don't know if it was stapled to or if it was just in the envelope, but we know it was sent together. I don't
Okay,
know
they were
anything
sent,
other than that.
the release and the offer of judgment were sent together. You concede that that's what the record says, right?
That is,
All
and
right.
it doesn't say anything else as far as any specifics of it.
All right.
But again, I think the big thing is it was conceded here today that this is a proposal that wasn't going to be accepted anyway. This is something that proposals are meant to end judicial labor, not to go fighting about these things when somebody's saying, I'm not going to take it regardless.
So from your perspective, Nichols doesn't really apply to this case, is that what you're saying?
No, it does not. To a certain extent, it does, to the extent that it says you have to look strictly at the proposal and see what it says and apply it as written. So it does for that reason, but not with regard to the release. And other than that, I think I would probably just be repeating what's in the brief, so if the court has any other questions, I'd be happy to answer them. Otherwise, I yield my time.
Okay, thank you very much. All right, you have 2.5 minutes left, sir.
With regards to this non-acceptance of this particular proposal, I just don't want there to be a mistake that the amount was the only thing that went into that consideration. Once again, the consideration in not accepting that proposal for settlement was the amount and the fact, which is very important because it goes hand in hand with the amount offered, is that I truly didn't think it had teeth. Didn't have teeth because, once again, of the joint proposal, and didn't lay out the differentiated amounts between the two defendants and the release issue.
Why
So-
did you just say it's not acceptable? Just write them back and say, we're not going to accept it.
Just because usually, Judge, I don't know, the practice is usually you just let the 30 days
Okay.
lapse and, it's rejected at that point. Okay. Thank you for your time.
Okay, thank you both very much.